now we have a particular pleasure. We've reversed the order a little bit, but I think only to whet your appetite even more as sort of the appetizer before lunch is going to be Judge U.W. Clemon, who I am really thrilled to have a chance to introduce. He is an extraordinary American leader and a dear friend to ACS. He is well known in this community, has an extraordinary list of accomplishments, and as much as we'd like this to be a week-long conference, it's unfortunately only a little over a half-day symposium, and so I can't go through the extraordinarily long list of achievements that Judge Clemon has had in his life. So I'm going to give you only the briefest sampling. Judge Clemon was Alabama's first black federal judge, appointed by President Carter in 1980. He served as Chief Judge of the Northern District of Alabama from 1999 to 2006. Before his appointment to the bench, Judge Clemon was a civil rights lawyer who handled school desegregation and employment cases, and you may recall that he famously sued Coach Bear Bryant in 1969 to desegregate the University of Alabama's football team. In 1974, Judge Clemon was one of the first of two African Americans elected to the Alabama Senate since Reconstruction. Before that, he was a student activist at Miles College, confronting the infamous Bull Connor over Birmingham's segregation ordinances and marching with Dr. Martin Luther King, Jr. in 1963. He's a recipient of numerous awards, a few of which are the Southern Christian Leadership Conference's Drum Major Award, the National Bar Association's C. Francis Stratford Award, the Alabama Bar Association's Judicial Award of Merit, and the American Association of Justices' Johnny Cochran Soaring Eagle Award. He has 2 streets in Birmingham named in his honor. The whole neighborhood, I think, the Judge Clemon neighborhood. He's a native of Fairfield, Alabama, one of 9 children of migrated Mississippi sharecroppers, and a 1968 graduate of Columbia Law School. I am so proud to be able to introduce to you Judge U.W. Clemon.
My brothers and sisters, it's a great pleasure to be here. I could blame it on this tardiness of mine. I could blame it on the fact that the elevators in the tallest hotel in the south of the Mason-Dixie sometimes don't work, or that the cab driver went the other way, but ultimately blame it on me. And I promise to you, make to you the same promise that Kim Kardashian apparently made to her husband-to-be. I won't keep you long. We in the civil rights movement very closely identify with this new anti-immigration movement. And we're reminded by the lessons of history of the purpose for which the 14th Amendment's Equal Protection Clause was adopted. You will recall that after the South lost the war and lost the right to keep some of us in slavery, it didn't give up. And the state legislatures enacted all of these black codes in an effort to keep us out. And they took away basic rights like the right to vote, the right to testify against whites in court, the right to be in town without having a job, required blacks to agree to work on an annual basis from sunup to sundown for wages of an unspecified nature, or if you refuse to do it, you could be arrested by the sheriff and contracted out to the plantation owners to work on the plantations without wages. And so it was the national outrage over this kind of injustice that gave rise to the 14th Amendment, the first sentence of Article 1 defining American citizenship as embracing all of those who were born and naturalized in the United States and subject to its jurisdiction. The second sentence, equally importantly, forbade the states from denying its citizens due process of law and the equal protection of the laws. And it was this that Justice Thurgood Marshall had in mind when he once said that this 14th Amendment means that under our Constitution, a black baby born to the poorest family on a Mississippi plantation is fully equal to a baby born to a Rockefeller in a mansion on the east side of Manhattan. Now, in the 1.5 centuries since the adoption of the 14th Amendment, we've seen constant challenges to the meaning of that amendment. 50 years ago, I was part of a movement which led to the restoration of some of the aims and purposes of that amendment. In fact, we were challenging the effort to keep us out. One of the challenges resulted in my going to Columbia Law School, most of which was cost of which was subsidized by the state of Alabama, so that I wouldn't enter the University of Alabama Law School. I'd take that choice any day. But the Alabama legislators knew that if they sent us out and we received better treatment elsewhere than back at in Alabama, we'd be unlikely to return. And those who stayed there were subjected to all kinds of injustices. The movement 50 years ago resulted in a significant progress in the aims that were set by those framers of the 14th Amendment. Today, with the election of the first president who is at least as much white as he is black, there has been a scary resurgence of racism in high and low places. The anti-immigration movement, in my judgment, is just another manifestation of the hatred and disdain on the part of white Republican state legislators for people who don't look or sound like them. It is completely irrelevant for their purposes that this anti-immigration legislation is irrational, taking its toll on the economy of the state with crops rotting in the fields, construction costs spiraling out of control, new businesses choosing to locate in less xenophobic states. Indeed, they enacted this repressive legislation without even bothering to read it. These laws, particularly HB 56 in Alabama, are today's rendition of the segregation laws of a half century ago. The old wine of states' rights and segregation comes today in a new bottle called federalism. As we consider the constitutionality of this new series of laws enacted by the states, under the Supremacy Clause of the Constitution and the Equal Protection Clause of the Constitution, we may well end up saving those who enacted the laws from themselves. But whether we incidentally achieve that result or not, we do the nation and that section of the nation in which we live a great service as we look at those laws in the uncompromising light of the Equal Protection Clause and the Supremacy Clause of the Constitution. I'm happy to be here with you as you undertake that effort here today. Was greatly educated by the preceding panel, and I'm sure will be even further educated by the panel to come. Thank you again for the opportunity of being here.